You're listening to Best Practices with Kenny Berger. On this podcast, we talk with the country's top trial lawyers about their approaches to every aspect of practice, from case selection to closing argument. And our guest today is my good friend, a mentor, and one of the leading trial attorneys in the country, Nick Rowley. Nick, welcome to the podcast.
Thank you. And partner. We're partners now.
And partner. So big announcement. Welcome to season 5 of Best Practices with Kenny Berger. We've got a huge announcement, and that huge announcement is TL4J South Carolina. So Nick and I enjoyed, at least on this end, I think on his end too, enjoyed working together so much on a recent case where we got a little fella and his family, life-changing money and real meaningful justice. That Nick was kind enough to extend the invitation to be part of the TL4J family. And, that's something you say yes to, and then you say thank you. So, man, I can't wait. Very, very excited for TL4J South Carolina.
Oh, we're excited. Thank you, Kenny. You're wonderful. You and your team, just great people.
You too, man. All right. Announcements are out of the way. Now we're going to talk about your most recent verdict, and this was trial number what for you, Nick?
184. Next one is 185. I find out if I get assigned out tomorrow. It'll be somewhere in LA, but trying cases in LA, it's a crapshoot most of the time. 95% of the time, you don't know who your judge is going to be, what courthouse you're going to be in. Is it going to be in Long Beach or Torrance or downtown LA or Pasadena or Sherman Oaks or Chatsworth or Pasadena, Pomona? You have no idea. So you show up because you better be ready. So you show up, on your trial day. You say, all right, we're ready to go, Judge. Judge goes, oh yeah, just come back in a couple of weeks. We don't have any courtrooms available for you. It's the worst place in the country to try a case in that regard. And then you don't know what your life is going to look like, right? Because it can take 2.5 hours to get to, one courthouse versus the other. And you might get assigned to a judge who tells you, you know what? I'm only in trial Tuesday, Wednesday, and Friday, or Monday, Tuesday, and Thursday from 9 to 12. And so now a case that would take me, a week or maybe a week and a half to try anywhere else in the country is now going to take 6 weeks. So it's really difficult for me as a national trial lawyer to take cases in LA, although I do, and I've got, partners in California that can do those cases. But I have no idea what my life is going to look like. And I have a trial that's supposed to start in Iowa coming up. I have a trial in Georgia that's supposed to be starting. And, this is what I'm doing. Frustrating.
And trial 184 was in LA as well?
That was in a long cause department in front of a great judge and one of the longest sitting judges in California, trial judges, Judge Zuliger. Great judge. And CVN broadcast the trial over the defense lawyers' objections because they didn't want to, get publicly beat, although they did. That was a long cause department. So when you're told to show up, you show up, and they call the jury in. It's real.
It's real. And Nick, will you tell us a little bit about that case?
Sure. That was a case that I've been on for a very, very long time. It happened 8.5 years ago. Wonderful woman, 34-year-old mother, Layla Miiamoto. She's rear-ended by an 18-wheeler, and her life was permanently changed. The defense threw the whole playbook at us, every defense you could think of, the lawyers directed the care and her medical treatment and medical conditions took on a life of their own because the lawyers got involved, where actually we're doing our job trying to help her get the care that she needs because her HMO and health insurance coverage put her in a place where she'd go into the doctor and she wouldn't even get to see a doctor. And they'd give her a referral and it would take months for her to see somebody, and it would be somebody who wouldn't give her the time of day. So yes, one of our most important jobs as lawyers is to help our clients get the care that they deserve, the care that they need. But what happens when we do that? We get attacked for it. They try to make it look dirty, but it's not dirty. It shouldn't be, at least. There are lawyers out there that, send people out for medical treatment that they probably don't really need. We are not those lawyers. Those are the minority. But you get attacked. And they had video surveillance that they threw at us that they, disclosed at the last minute. They had experts coming in saying our client was an exaggerator. Just everything you could possibly think of was thrown at us, in this trial. But we knew it was coming. So we prepared for it, not just over a period of months, but over a period of years. This is a case that was supposed to go to trial 4 years ago, and it didn't go. And so it kept getting delayed. So we finally got it into a long cause department in front of Judge Zuliger, and got a good trial date that stuck, and got Layla the justice that she deserves.
And Nick, in terms of dealing with these attacks that you knew were coming, or those things primarily you dealt with in voir dire and opening? I know we've talked about the concept of sponsorship and being careful
Sure.
with the defense
Right.
argument you sponsor.
Yeah, that's a good question. Good point, Kenny. The video surveillance was something that I went back and forth with. Do I want to to bring this up and sponsor it or not, or let them do it and then, shove it up their rear ends? I decided to actually bring it up because they were bringing it up during jury selection. So the jurors knew about it. So I decided to take it head on. And we actually I played some of it in opening statement and showed the jurors, this is what they've done. They've gone around following her around with a video camera, sneaking around. And what did it show? They had to turn it over to us. It actually shows she's hurt. So we embraced it. We made it part of the case and beat them over the head with it over and over again.
Yeah, and Nick, I know in texting a little bit and seeing some emails while this trial was going on. I mean, again, like you said, they kitchen sink all the defenses
Oh yeah,
and
everything.
and some of the experts they brought in. I know you had a good time with on cross. Can you talk about one or two cross examinations that stand out and some of the things that you did that you found
Sure.
effective?
Sure. Well, one cross-examination, one of our partners, one of your partners, Keith Bruno, tried the case with me. He jumped in at the last minute. We're always there for each other. And they brought in three of the top defense lawyers, on the West Coast to try the case against me. I'm like, whoa, hold on. Like, hey, Keith, when I joined, he's like, oh yeah. So Keith jumped in. He cross-examined the defense economist. What we chose to do, we had our economist meet us at the courthouse, and we went out for lunch and we started talking. And some of the numbers had changed, and that put him in a I wouldn't say a difficult position, but he said, hey, they're really going to come at me because I did my analysis based upon these other numbers, and now the numbers are different for future economic damages. And I said, hold on, who has the burden of proving to the jury that the amount of damages should be reduced to present value? Who has that burden? Under the law, the defense has that burden. So we had a good lunch, and I sent my expert, who I've known for a very, very long time. I sent him home. I said, you know what? We're going to make the defense prove that. We're going to cross-examine him. And what we did was we put together a graph showing that the rising cost of healthcare over the past 50 years has exceeded the rate of reasonable and safe investment. So we were able to cross-examine the defense economist and say, hey, hold on, look at this graph, look at the numbers. You're saying that if we, invest this money, that it's going to provide X amount of dollars over the course of Layla's life, right? To give her care, but we only need this much to invest to get her the amount that she needs. But hold on, wait a minute. If we take your number and the rate of investment and we look at history, the rate of medical inflation and rising healthcare costs exceeds the amount of that investment. So she's actually going to need more money in the future. And so we did that, and Keith did a great cross-examination. And one of the things that I asked him to throw in there is I said, let's talk about the $6 million man. We had people on our jury who were old enough to, I'm old enough to know who the $6 million man is, because I was born in the 70s. And so he asked the defense expert, he goes, well, let's talk about the $6 million man. In 1973, he was worth $6 million. Wouldn't that be like $45 million nowadays? And he did it in a joking way, and the defense didn't even see it, just went right past him. And that was the setup for our closing argument, where we dealt with their video surveillance. And I actually have that, and I could play it if I can share my screen. All right, this is how we dealt with their video surveillance.
We heard about the $6 million man yesterday. Now look at the defense lawyer's body language, Dana Fox. It's priceless.
And Nick, the folks who don't know, I mean, Dana Fox is kind of like the guy or one of the guys in California when it comes to insurance defense.
Oh, he considers himself, and some consider him, the king.
Right.
Yep. We've had trials and they're all 8-figure verdicts. So, and I'm not too fond of him for a number of different reasons, but check him out.
Yeah.
So this is during closing argument. This has not been exchanged. The defense doesn't know it's coming. And the jurors have seen this video surveillance throughout the trial. The defense has used it, cross-examining our client, cross-examining her husband, cross-examining witnesses, talking, about this video surveillance with their expert witnesses, saying, oh yeah, she's out. She looks normal, right? There's not really much wrong with her. So the point is what did it take to get her to the point? With all the king's horses and all the king's men, putting her back together again, what did it take to get Layla Miiamoto to the point where they could go out there and get some cherry-picked video footage? Well, here's what it took. Their surveillance. Kind of forgot to mention, yeah, there's been a lot that's had to go in to Layla Miiamoto so that they can catch that surveillance. That's what I think of it. Maybe look at that. He gets up and talks about it. Let's think about everything that's been put into her body and everything she's gone through just to be able to walk. To be able to give up that cane. To be able to get by.
Strong. And again, I love that you let all the jurors' focus and attention go to what you were showing and didn't make yourself the center of their attention when you wanted their focus elsewhere. And I loved watching the defense attorney squirm. Who did the tech on that for you, Nick?
DK Global, huge shout out to DK Global. I called them on Thursday, knowing we were going to close potentially on Monday or Tuesday. We started closing on Tuesday, and I called Michael Caldwell up. I said, "Hey man, I got an idea," and he said, "I love it." And so they worked on it, day and night for the next 3 days to put this together, and it was, I mean, the judge's face, and I looked over him afterwards. He was just He was absolutely thrilled with it. And what's the defense going to do? What are they going to do? They're going to object. Like, what? Really? I mean, I've sung songs in closing argument. Closing argument, that's the time to take the evidence, to take the facts and use your imagination and do something powerful. Do something that nobody could ever anticipate. Right? That's the time to take all that you are, right? And become an artist in the courtroom.
Yeah, and so, long before we were ever partners, long before we knew each other, I read Trial by Human. And maybe the part that stuck out most of all for me, either in the book or reading more about the trial, I believe is when you held the child during
Sophia.
Sophia, and not something you planned on, not for theater, but it hit you in the moment that this is what the parents are doing, and this is what they'll do because they love her. For me, that was one of the most powerful emotional responses I had to the book. For me, that people, seen the chicken suit and are familiar with the case, but you holding Sophia, especially now as a parent, it's like, man,
Yeah.
still hits me.
Yeah. And telling in the moment in that trial, I looked over and I'm like, boy, that beautiful little girl, she's getting big. She's getting real big. And I love holding my kids, as they get bigger and bigger and bigger. And then at some point you can't really hold them anymore. Well, Sophia's going to continue to grow up. I mean, she's beautiful. She's, boy, her parents are so amazing. And that little girl's so healthy, but she's permanently damaged and she's never going to be able to walk by herself or hold herself up. And so I picked her up and I went over, I stood in front of the jurors and I said, she's so heavy, and her parents had been holding her and carrying her and we're carrying her, but she's just going to keep getting bigger and we can't carry her alone. We need your help. And it was a powerful moment in that trial.
It was just so true. I mean, it cut through everything right to the truth. And Nick, one thing that stood out in talking about Layla's trial and other cases you've tried amongst the 184, soon to be 185, is your team approach. Reaching out to DK Global, talking to Keith Bruno. Will you share just the things that you enjoy about collaboration and why you think it makes you a better advocate and overall better for the client?
No, absolutely. So I have found that working with a team is the best way to win. It's pretty lonely, pretty lonely in the courtroom. You're trying cases and, doing your best. And I've tried so many cases alone. When I try cases with a partner, with someone else, it's more fun. And there are things that other people bring to the table. You have to check your ego a bit and just say, hold on, maybe these jurors are going to receive things that Keith Bruno or Kenny Berger can deliver that I can't, right? Because as human beings, think about it. There are people that you're going to connect with in a certain way that I'm not going to connect with in a certain way, and vice versa, right? People that might, hear my voice and say, all right, that's good. But they hear your voice, might say, wow, that actually connected, with me. So the more, and I mean, don't, bring a whole bunch of people into the courtroom, right? You've got to be very precise about who you're involving and how you're going to sequence the trial. But if you're trying a case and you're alone, think about it. Think about it. Would my client be best served if I brought in someone else? I don't know of anyone who's climbed Mount Everest alone, right? It's usually something you do with somebody else or a couple people, and you're tethered to each other, right? Because if one falls, you can pull them up and save them. And there have been times in trials where someone I'm trying the case with, sees something that I don't, or I get to check in and say, hey, did I go too hard on that witness? And that happened during this trial. I said, did I go too hard? And Keith said, I think you got right up to the line. I'm not sure. I don't think so, but I'm a bit biased, right? And that tells me, okay, I need to tone it down with the next witness because I got a little carried away, right? Or I got upset because we're human beings, right? You have somebody up there like Dr. Chang. She was the defense neurologist, and she came in and took a big old giant expert shit on the case. Called Layla faker and exaggerate. I mean, she just went for it. And so I got up and cross-examined her. And I mean, you can watch that on CVN. We don't have time to look at it right now. We're going to do a case analysis, I think in March, where we're going to, break down the whole trial, and we'll play some of that. Well, she got it handed to her, but being able to check in with Keith and check in with John Kawai. John Kawai is one of my amazing partners who's tried many cases with me, and he was there and he was part of that trial, as was Pat Logan and Nagin. We had the whole team, but I was able to turn to them and say, hey, am I all right here? And they said, oh yeah, you're good. Like you're fine. So then I, keep going. And then sometimes there are things that, I turn to one of my partners and say, hey, you got anything else? And they've got a sheet of paper with a whole bunch of questions and points for me. I go, shit, wow, I didn't think of that. Because when you're in the moment, right, sometimes you miss things. Also, when you're trying a case, it's exhausting. This was a trial that lasted a month. And we've got other cases, we've got our family, we've got our health. So when you bring somebody else in, it's more fun. It's more fun if you're doing it right. You can, take some of the burden off of your shoulders, and you're giving the jurors, something other than just you. And the question is that the best thing for your client? And in this case, it was. In this case, it was. I can't say that I would have got this result without John and Keith and Pat and Nagin. Maybe, but maybe not. Maybe not. Because you get a couple jurors on there that say, maybe, and I have a pretty strong, personality. Maybe I do something and it just irks one of the jurors, right? It's going to be tough to get them back, but if I'm not the only one that they have to listen to, then it makes it easy for them.
Nick, going back to, when on at least one of these examinations on the cross, where you're checking in with Keith and asking, did I go too far? When you're doing the cross, what are you paying attention to? Kind of where are you in terms of monitoring kind of how hard to go, how close to get to that line, when to pull back? What's kind of going through your mind, or what are you using to decide how hard to push, how soft to pedal?
My gut, my experience, I'm also reversing roles with the jury all throughout the trial. And, how are they, taking all this in? What more, if I was juror number 3, juror number 2, what else do I need? Sometimes I'll look over the jury too. And I'll ask, one of my partners say, can I stop now, or should I? Or are there more questions asked? So I'll look over one of the jurors, and jurors will be like, okay. And so, then you can stop. But I'd say in this trial, every cross-examination went just really, really well, except one. There was a neuropsychologist that I cross-examined, and he was just a greasy shit weasel. Didn't like him much at all, and he wouldn't answer my questions. And I got into it with him. And then there was an issue that I was right on, but the judge just didn't see it right. And so the judge, told me to stop. I was asking questions about, what was it? I think it was Layla's grades. Yeah, her grades in high school. She's 34 when this happens. And these, assholes wanted to, bring up her high school grades when her parents got divorced and say, oh, look, she got 2 Fs. Like, what does that have to do with anything, right? When she's 16 years old, now she's a 34-year-old mom who gets hurt. And at the time of trial, she's 42. And they want to talk about her high school grades when she was 16. I mean, boy, you should see my high school grades. I was kicked out of every school from 4th grade through high school till I went into the military. My grades sucked. And so, that pissed me off a bit that the defense was trying to do that. So I wanted to, shove it up their rears with their neuropsychologist. And for some reason, the judge just wasn't going to let me do it. So I asked the question this way, asked the question that way. He told me to move on, and then told me to stop the examination. If I didn't, I said, no, I have more questions. So I started getting into it with the judge, with this witness, and that didn't feel good. Didn't feel good at all. So I checked in I checked in with Keith and John and the team, and I'm like, hey, we all right here? And they said, just keep going, keep going. And eventually I got him. If you want to see a cross-examination that didn't go perfect, but at the end, you just kept working, kept going, didn't stop, didn't give up. And then, you get him at the end, that's one. But after that, right, that was messy. That was messy. I rolled in the mud or in the shit with the pig, right? And even though I think I won the wrestling match, I still, was covered in it a little bit. That was time for me to now sit down and let someone else take a witness so the jurors could get a break from that energy that went on in the courtroom with me, getting into it with the judge, getting into it with the witness. Yeah, I got him in the end, but the jury wouldn't necessarily have been as open to hearing what I have to say with the next witness. Also, the judge needed a break, right? Because we had got into it. And even though he was wrong, and we talked about it afterwards, and he gave me his reasons, but in the moment, he was wrong, I was right. You're still not going to win that battle. The judge needed time to cool down because we had an interaction. And as a lawyer with a bit of power, I'm not going to let a judge shut me down. So when a judge is trying to shut you down, it's like, nope, it's not happening, right? And you stand up a little taller and start getting into it with the judge. If you don't give the judge and the jury a break from that energy, maybe the next witness isn't going to go so well. And when you're doing a long, intense trial, it really benefits the case to have other people involved where you just, okay, now I'm going to sit down, sit back, breathe a little bit, take a break. Maybe come back in tomorrow and the jurors can hear from me. Or it also gives me a chance to reset, right? And get up and bring in a different energy with the next witness. And I think if you followed the whole trial, you'd see that.
Absolutely. Nick, for folks who want to know just what you find to be the most essential aspects of preparing for cross-examinations, what guidance would you give?
Well, you need experience, right? So the more you do it, the more depositions you take. And in depositions, you can test things out, right? You can try different methods and try to, find what you're best at. Because there's a way that you might cross-examine a witness that is very different from the way I'm going to cross-examine a witness. Don't try to be me. You're not going to be me, and I'm not going to try to be you. I can't be you. I might learn some things from you. You might learn some things from me, but experience is going to help you find your footing. So get out and do as much of it as you possibly can. Try any case that you possibly can. Take tough depositions and work on your cross-examination skills. Read Posner and Dodd, the science of cross-examination. That's a very, very good book. I read that, way back when. And then ask yourself with each witness, how can I advance my case? With every witness, you can advance your case somehow. Right? What's a fact that I can prove or a fact that I can establish or reestablish with this witness? And tell the story. This happened. The witness might get up and testify to A, B, C, D, E, and F. It doesn't mean you need to talk about those things, right? You could go talk about, Z, W, X, M, and O, right? Take the jury somewhere else with that witness. Don't necessarily, jump into the cage and let them, control the narrative. And if a witness said something that hurts your case and there's nothing you can do about it, then don't try to do anything about it. Go somewhere else with it. Leave room for the possibility that maybe that flew right by the jurors. Or maybe the jurors have reasons why they don't believe that witness or why what you think hurt your case actually didn't hurt your case. But if you now go start having a fight and now sponsoring it, bringing more attention to it, right? What you're doing is causing self-inflicted wounds.
Yeah.
Right. So I like to advance my case on cross-examination, as much as possible. Most defense lawyers, learn after calling one or two, or if they've tried cases against me, that they know that calling witnesses is just a freaking bad idea. And if you watch the Miiamoto trial, the court reporter actually said something to us. She said, I've never seen a trial where every single witness the defense calls ends up becoming a plaintiff witness.
That reminds me of, I didn't ever get to meet Jerry Spence, but obviously know that's one of your mentors and kind of maybe in fact the lawyer who inspired you to become a lawyer. But I remember it's either one of his audiobooks or otherwise, but it was talking about, I think during Ruby Ridge, and maybe there have been 42 government witnesses, and on one of the breaks, court reporter comes up or someone and says, Jerry, there have been 42 witnesses, and I know they called them, but it feels like you're 42 for 42 on making these people your witness.
Yeah.
And so when you were talking about, these folks becoming your witness, I love that there's a lineage here.
Randy Weaver was from my hometown in Iowa. And watching Jerry Spence represent him, defend him, because he was the troublemaker in town, Randy Weaver was. And when Ruby Ridge happened, everyone said, oh boy, he's at fault. They ought to shoot him. Right? He's the one that caused this whole thing. Well, Jerry Spence came in and showed the truth, showed us the other side of the story, the true side of the story. That's what motivated me to become a lawyer.
Nick, going kind of where really it seems like all these cases start for you and started for you and the client. And you talking about Layla here, and the passion comes across beyond just being a good human being and really becoming a great advocate. Will you share with us just how critical it is and how powerful it is to really get to know and love your client?
Sure. It's everything. I called Layla, when the verdict came in, and I said, do you remember what I said to you when I spent time with you and your daughter about 7 years ago? She goes, I remember. I spent time with them. We met up in Santa Barbara, and just, there's this new case, and, we're being asked to come in. And I said, well, we got to meet the client, got to meet her. So she came, brought her daughter, and I got to know her. And I told her, I said, I believe in you. That you've been hurt, they're in the wrong. They can deny liability all they want, but I believe in you, and I'm going to take your case to trial. I don't know how long it's going to take, but we're going to get there. We're going to get you a jury, and we're going to get you justice. I believe in you. And I did. And I remember that time that I spent with her, and the time that, a number of members of our team spent with her, getting to know her, getting to care about her, love her. And that really carried us through, because the defense, they offered 5.5 million, years before. And to have this woman who can't work, who's a stay-at-home mom who homeschools her kids, who really can't do it that well anymore, to say no to what would have put, a couple $1 million in her pocket, and to trust us to say no, to trust us when they call. In fact, when they called me on Saturday after closing argument and said, hey, we got 9 million for you. I said, well, first they said, I know that you told us not to talk to you about money and not to come to you with any settlement offers, but it's my obligation, my duty, to make you this offer. And I used some choice words and they said, well, the tower is told. I said, well, you tell the tower to go. But Layla trusted us, right? And we were connected. And I had her permission to say no. I didn't even need to call her and say, hey, you know what? They made a new offer on the case. I already had her permission to reject anything, unless I felt that it was right. So that trust comes with human connection and spending time. If we didn't have that connection, then Layla would have settled for, the 5.5, long time ago. Now, if we hadn't been involved with the case, they would have never offered 5.5. But now I got a call yesterday from the defense, and it looks like they're going to pay the 37 million. that they owe with all the interest and costs. So that's good.
Yeah, it's a great example. 5.5 sounds like a lot. 9 sounds like a lot. Compared to 37
Right.
for what this woman went through. I mean, the demonstration you showed earlier, what stuck out to me was the number of injections on that visual that you showed into her,
Her
into
body, her head, the headaches, the neck pain, she's tried everything. And that's the thing, with each of these defense witnesses that got on stand, I said, hold on, how hard has she worked to get better? She's worked really hard, hasn't she? She's followed every piece of, and one of the, every piece of medical advice that they gave her. But they had some witness get up and say, oh boy, she was recommended cognitive. It was actually a treating physical therapist that runs the chronic pain, department at Kaiser. She was awful. She was awful. They found that they found this evil, rude, physician assistant come in and say Layla was an exaggerator. And she said, oh boy, I knew the moment that I first met Layla, I opened the door, the patient room, and she had all the lights off and she was laying down with her sunglasses on. And I knew from my experience working with, neurologists and seminars that, that's an exaggerator. And so the cross-examination was, well, did you know those are prescription glasses, prism glasses, and they're shaded for a specific reason because she has light sensitivity ever since her head injury? Oh no, you didn't know that. And what's really funny is that witness, she testified via Zoom and she had glasses on. And so when I came back after, we had a lunch break and then we came back and the cross-examination continued. My first question was, are those prescription glasses? It's like, no. But that physician assistant, the defense chose to use her to say that she recommended cognitive behavioral therapy and that Layla never went and got it. So we were able to show actually she did. Actually, she did. She had 82 appointments that she went to for cognitive behavioral therapy. That PA didn't know because it was outside the Kaiser network because Layla couldn't get the darn appointments through Kaiser. That she went through everything she possibly could trying to get better, and she's still not better.
And Nick, I mean, one thing that stands out, is when you look at a case, you look way, way, way beyond the medical records.
Oh yeah.
And at the same time, again, hearing you talk about it, you also know the medical records in terms of what you need to know backwards and forwards. I mean, just the level of preparation. Could you just talk for a minute, be it in a, med mal case, brain damage case, or otherwise, why it is that your first thing is the client and not just what those medical records say?
Sure. Medical records are not gospel, right? This is history being written by people who they're not your client. They're not the human being whose life has been impacted. So the way that they might be seeing the world, through a certain lens with a limited amount of time isn't necessarily the truth. Medical records are not the end all be all of a case. And if you're just focused on the medical records, you're going to lose sight of the human story. And I think most jurors nowadays know that medical records are oftentimes inaccurate. They don't tell the whole story. And if there is a medical record that says something that the defense, they think they're going to hang their hat on it, right? Well, put it into context, right? Put it into context. They're one piece of a case. Lawyers spend too much time focusing on the medical records or the medical bills.
And Nick, that leads into my last question. We were talking about before we came on. I've been over at the South Carolina Senate today, testifying and fighting back against an insurance bailout. I mean, it's the big insurance bailout bill. But one of the things that came up in the subcommittee hearing was people talking about non-economic damages. And you could tell the way they were being talked about that somewhere along the line between when they walked into a law school building and when they walked into that Senate subcommittee hearing, that they totally lost sight of what it really means to say non-economic damages, and that we're really talking about is life.
Quality of life damages. They're quality of life damages, right? Life, liberty, the pursuit of happiness. That's what those politicians have all taken an oath to protect, right? our civil rights, our fundamental liberties, life, liberty, the pursuit of happiness. That's what non-economic assets are, right? When those things are trampled upon, torn, ruined, bruised, destroyed, changed, right? Now they change from assets to damages, right? There's a transition. So you have to ask these politicians, how important is your life, your liberty, right? Your happiness. What's more important, your house, your bank account, or your life, liberty, pursuit of happiness? How about, let's talk about a loved one. What's more valuable to you? Your dad's paycheck, right? Or how he might, help you every now and again or not, or his love, his companionship, his advice, his fellowship, right? What's worth more? Oh, well, they're going to tell you, those things those are called non-economic assets. And if those things are taken away, now they're damages. And you mean to tell me that you're going to let an insurance company propagandize you and get you to pass a law to take away a person's right to get compensated for the loss of quality of life, for the loss of liberty, the loss of pursuit of happiness? What? That's un-American is what it is. And the only people it benefits, it's not even people. It's a corporation that has, money running through its veins. These billion-dollar insurance companies. It doesn't benefit anybody else in any way, shape, or form. It's absolutely un-American to put caps on those very, very important assets.
Thank you. Thank you. Yeah, and it's not a political issue. I mean, one of the things I've talked about, South Carolina values life.
Yeah.
South Carolina values children. South Carolina values the unborn.
Yeah, family.
And once we get into the point of life, to say it's worth nothing or worth little, goes against everything.
There's a one-size-fits-all value of it, really?
Yeah, and that my wife, that her life is worth less. My child, now that my dad's retired, the day at my dad's retirement party, we didn't say, "Dad's worth less now."
Right.
It's so absurd when you really play it through. So thank you for speaking to it. Man, you're the best. Love being able to call myself a friend of yours, a partner. Man, and just look forward to doing great things together, and appreciate all the work you do across the entire country and really the world at this point, man. It's remarkable. So thank you.
Well, thank you, brother. Thank you, guys.
All right.
Thanks.
Yeah, folks, guest today has been Nick Rowley. Thanks so much for joining us on Best Practices, and look forward to telling everyone more about trial lawyers for justice in the weeks and months to come. Take care.